All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good afternoon and welcome everyone to this initial appearance hearing. Madam Court Officer, could you please call the case?
Good afternoon, Your Honor. This is file KAC BC 2023-12. The Specialist Prosecutor versus Hashim Thaçi, Bashkim Smakai, Isni Kilay, Fadil Fazliu, and Hayreddin Kuchi.
Thank you, Madam Court Officer. Before we start, I would like to give the photographer the opportunity to take some pictures. Mr. Fazliu, is it agreeable to you if the photographer takes a picture of you today? Turn on the microphone. We haven't heard the response of Mr. Fazliu, I'm afraid.
Yes.
Thank you, Mr. Fazliu. Madam Photographer, you may proceed. Thank you, Madam Photographer. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of the rules that must be observed at all times in order to facilitate the smooth conduct of the proceedings. Please ensure that you activate your microphone before speaking and that you switch it off as soon as you are finished. Talk slowly and clearly as we have interpretation from and to Albanian and Serbian. Wait 5 seconds before responding to me or a party in order to allow the interpreters to finish the interpretation. I would also like to remind you that certain information in this case is subject to confidentiality. Confidential information shall not be disclosed in open session. If any party wishes to refer to or discuss any confidential information, please request to go into private session. Now, I would kindly ask the parties to introduce themselves with the Specialist Prosecutor's Office to start.
Good afternoon, Your Honor. Josh Afitz on behalf of the Specialist Prosecutor's Office, and I'm joined today by my colleagues Kim West, the Specialist Prosecutor seated behind me, Gaia Pergolo seated to my left, and Fabian Unsernad in the background. Thank you.
Thank you. Now the defense, please.
Thank you, Your Honor. My name is Michiel Michael Pestman, and I'm counsel for the accused.
Thank you, counsel. And for the record, I note that your client, Mr. Fazliu, who already spoke during this hearing, is also present in the courtroom. I will now turn to the registry, please.
Good afternoon, Your Honor. For the record, Jonas Nilsson, Deputy Registrar. I'm here with Whitney Price, Legal Counsel. Thank you.
Thank you. And last for the record, Marjorie Masselot, pre-trial judge for this case. The accused is appearing today for the first time before the specialist chambers following confirmation of the indictment against him on 29th November 2024. Mr. Fazliu, will you please stand and turn on your microphone? Could you please state your full name?
Oh, Fadil,
Yes, Fadil Fazliu.
What is your date and place of birth, please?
Pasmet,
15 July 96 in Laush, Podujev municipality.
Pristina.
I live in Pristina.
And what is your citizenship, or what are your citizenships in case you have several?
Vetëm një i Kosovë.
I am Albanian of Kosovo.
What is your current profession?
Jem magjistri shkencave emergjente.
I am a Magister of Emergency Science Protection at work.
All right, thank you, Mr. Fazliu. Before we...
Sorry to interrupt you, Your Honour, but I know he looks very young, but he's not born. He was not born in 1996, but in 1960.
So in
60, 1960.
Correction, 1960 I said. I said I was born on 15 July 1960.
now on the record accordingly. Mr. Fazliu, before we proceed any further, I have to make sure that you can follow the proceedings in a language that you understand and speak. Can you confirm that you understand and speak Albanian?
Oh,
Yes, I do.
Thank you, Mr. Fazliu. By this, I'm satisfied that you can follow the proceedings in Albanian, a language that you understand and speak in accordance with Rule 92 of the Rules of Procedure and Evidence. If at any moment, Mr. Fazliu, in the course of the proceedings, you are not receiving interpretation, please draw my attention to it immediately. You may now be seated. I will give a short procedural history to introduce today's initial hearing. On 29th of November 2024, in my capacity as pretrial judge, I partially confirmed the indictment submitted by the specialist prosecutor against Mr. Hashim Thaçi, Bashkim Smakai, Hisni Kilay, Fadil Fazliu, and Hayreddin Kuchi, charging Mr. Fazliu with one count of attempt to obstruct official persons in performing official duties by participating in the common action of a group, and one count of contempt of court. I also issued an arrest warrant for Mr. Fazliu on the same day. On 5th of December 2024, the SPO arrested Mr. Fazliu in Kosovo, and he was served with the arrest warrant, the confirmed indictment, and the decision on his arrest warrant translated into Albanian. On 6th of December 2024, Mr. Fazliu was transferred to the detention facilities of the Kosovo Specialist Chambers in The Hague. That same day, I issued the decision setting today's date for the initial appearance. Now, allow me to recall the specific purpose of this initial appearance for the benefit of Mr. Fazliu. Today's hearing is not a trial. No evidence will be presented or debated, nor will the guilt or innocence of the accused be discussed or decided. The very purpose of this initial appearance hearing is regulated by Article 39(5) of the law and Rule 92 of the rules. According to these provisions, as a pretrial judge, I shall have the charges in the confirmed indictment read to the accused, Confirm that the accused understands the indictment. Satisfy myself that the rights of the accused, in particular his right to counsel, are respected. And inform the accused that within 30 days of today's hearing, he will be called upon to admit guilt or plead not guilty on each charge set out in the indictment. If the accused wishes to do so, I will get back to that, he may also immediately admit guilt or plead not guilty. And finally, I shall set other dates as appropriate in performing my functions as pretrial judge. These are the matters which will be addressed in turn during today's initial appearance. Should either party wish to discuss any other matter not expressly foreseen in the context of this initial appearance, I invite you to do so through a filing in written form. First, Mr. Fazliu, I invite you to please stand up. May I ask you to confirm that you have received the confirmed indictment in a language that you understand and speak?
Yes, I have.
Thank you. Before, Mr. Fazliu, before Madam Court Officer reads the confirmed charges against you, I wish to remind you that this is not the time to contest them, but simply to acknowledge your understanding thereof. You will have the opportunity to challenge the charges with the assistance of your counsel. And I will now ask Madam Court Officer to read out the charges in the confirmed indictment as foreseen in Article 39(5) of the law and Rule 92(2)(b) of the rules. You may be seated, Mr. Fazliu.
Thank you, Your Honor. 1. In the confirmed indictment, the Specialist Prosecutor charges Mr. Fadil Fazliu with Count 16, attempting to obstruct official persons, in particular SPO prosecutor and investigators, in performing official duties by participating in the common action of a group, punishable under Article 401(2) and 5 of the 2019 Kosovo Criminal Code, and Article 15(2) of the law. And Count 17, contempt of court, punishable under Article 393 of the 2019 Kosovo Criminal Code and Article 15(2) of the law. 2. These offences were committed between at least 26 June and 18 July 2023. 3. In relation to these offences, there is a well-grounded suspicion that Mr. Fadil Fazliu is criminally responsible pursuant to Article 16(3) of the law for a. committing the offence of attempted obstruction of official persons performing official duties under Count 16, pursuant to Article 17 of the 2019 Kosovo Criminal Code. b. Assisting Mr. Hashim Thaçi in the context of the group in the commission of the offence of attempted obstruction of official persons performing official duties under Count 16, pursuant to Article 33 of the 2019 Kosovo Criminal Code. c. Assisting Mr. Hashim Thaçi in the commission of the offence contempt of court under Count 17, pursuant to Article 33 of the 2019 Kosovo Criminal Code, and d. agreeing to commit with Mr. Hashim Thaçi in the context of the group in the commission of the offence of attempted obstruction of official persons performing official duties under Count 16, pursuant to Article 35 of the 2019 Kosovo Criminal Code. Thank you, Your Honor.
Thank you, Madam Court Officer. Mr. Fazliu, did you understand the charges contained in the confirmed indictment as read to you by Madam Court Officer?
Pjesërisht.
Partially.
Po.
Yes.
there's something you did not understand? You mentioned partially, I think.
I kom kuptue.
Yes, I understood them.
The law on the specialist chambers and the rules of procedure and evidence guarantee you a number of rights, and I will read out the most important ones, especially those relevant at the specific stage of the proceedings. So, Mr. Fazliu, you shall be presumed innocent until proven guilty beyond a reasonable doubt. In the determination of the charges against you, you are entitled to a fair and public hearing, subject to any measure ordered for the protection of victims and witnesses. You have the right to be informed promptly and in detail in a language which you understand of the nature and cause of the charges against you. You have the right to have adequate time and facilities for the preparation of your defense and to communicate with the counsel of your own choosing. You have the right to be tried within a reasonable time. You have the right to be tried in your presence and to defend yourself through your counsel. You have the right to have counsel assigned to you and without payment if you do not have sufficient means to pay for it. You have the right to receive the free assistance of an interpreter if you cannot understand or speak the language used in the court. You have the right not to be compelled to testify against yourself or to admit guilt. You have the right to remain silent, and no adverse inference shall be drawn from your silence. And you have the right not to be detained for an unreasonable period of time prior to the opening of the case to request review of decisions on your detention and to appeal such decisions directly before the Court of Appeals. Mr. Fazliu, I have read to you the most important rights that you enjoy in accordance with the applicable legal framework of the specialist chambers. Do you understand these rights?
Po.
Yes.
Thank you, Mr. Fazliu. I wish to inform you also that according to Article 21(5) of the law, you may not represent yourself because you are currently in detention. Representation by specialist counsel is therefore mandatory. I take note that you are represented by Counsel Pastman today. I'm therefore satisfied that the accused is presently represented by counsel. I see that there is an issue with a... Is it anything you would like me to repeat, Mr. Fazliu?
Yes.
Mandatory, and I had just taken note that you are represented by Counsel Pastman, and that I was therefore fully satisfied that you are presently represented by counsel. I will now turn to your right to enter, as mentioned previously, an immediate plea, if any, in accordance with Rule 92 of the rules. Mr. Fazliu, within 30 days from today, as already mentioned, you will be called upon to admit guilt or plead not guilty on the charges in the indictment. If you wish to do so, you may choose to immediately, at the present hearing, admit guilt or plead not guilty. I would therefore like to ask you, Mr. Fazliu, if you had the opportunity to discuss the charges in the confirmed indictment with your counsel, and if you are prepared to enter a plea at this time.
Po, do deklaruję
Yes, I will declare myself innocent.
potem
I discussed with my counsel, but I plead not guilty.
pofaj.
I declare myself innocent.
Noted, Mr. Fazliu. As you have chosen to plead not guilty on all counts, the pretrial proceedings will continue with a view to preparing this case for trial, pursuant to Rule 95 of the rules. Let us thus now move to the working language of the proceedings. In the decision setting the date for today's initial appearance, I invited the parties to make oral submissions at today's hearing on the working language to be used in the present case according to Rule 8 of the rules. And I would now like to know the preference from each party. I will give the floor to the Prosecutor's Office for the third time on this matter.
English again, Your Honor. Thank you.
And of course, Counsel Pestman, you have the floor.
Thank you. English as well.
This is well noted, and I will issue a decision on this matter in due course. In the decision setting the date for today's initial appearance, I also indicated that I intend to schedule the first status conference in this case, pursuant to Rule 96 of the rules, on Tuesday, 17th of December 2024 at 2 o'clock. I have also invited you to provide oral submissions at today's initial appearance on whether counsel and or the accused intend to participate in the status conference in person or via video conference. Counsel Pestman, you have the floor.
My client and I will both attend in person.
All right. This is noted. For the Prosecutor's Office, as to the date.
We'll be here in person, Your Honor.
Okay. Thank you. You will receive a scheduling order in due course as well. That will also include the agenda. And I will, in that scheduling order, provide guidelines on the requirements for attending the status conference via video conference in case this becomes necessary. We will now move to the next point, which is the detention of Mr. Fazliu. Mr. Fazliu, I recall that based on the finding of well-grounded suspicion that you committed the offenses that were just read to you, an arrest warrant was issued against you on 29th of November 2024. Pursuant to Article 41(6)(b) of the law, your arrest was found necessary based on the existence of articulable grounds to believe that you are a flight risk, you may obstruct the progress of the criminal proceedings, and you may repeat said offenses. I also recall that you were served upon your arrest with my reasoned decision on request for arrest warrant and related matters translated into Albanian together with the confirmed indictment. Now I would like to know whether the defense wishes to make submissions on the issue of detention.
I'm counting till 5. I think, yes, Your Honor. I would like to request for my client's provisional release and to set a bill. I can provide you with my arguments now, or would you like me to do so
Absolutely,
later?
I'm expecting you to do so, yes.
Okay, thank you. I only met my client yesterday, so I did not speak to him for very long, but I would like to introduce him to you so that you can get to know him. And I would like to tell you and also the prosecutor something about his personal circumstances, which I think are relevant for the decision you will hopefully be able to take today about the detention, the remand. He was arrested, my client was arrested on his way to work on Thursday. He always walks to work. He works, as he already explained, as a coordinator for the central office of the energy supply company in Pristina. This is not a government institution, this is a privatized energy company. And I'm telling you this because it is important, because he expects and he fears that he will lose his job if he's detained for too long. He is currently still earning 850 euros a month, 650 euros after taxes, and has savings of less than 1,000 euros. I'm telling you this because I will ask you to set bill at a certain amount afterwards or later. He lives in Pristina with his wife, son and daughter. His son works as an income of 500 euros a month, and his daughter is currently studying. They're both in their early 20s. He has serious medical issues. I will not go into detail, but he has a heart condition for which he requires special medical attention, and he also has diabetes. He has, of course, specialist medical care in Kosovo. As said, he is worried, and I believe with reason, that he will lose his job and his salary, and that will have not only serious consequences for him, but also for his direct family, the one he's sharing his house with. He has a fixed address, by the way. There's not going to be very difficult to find him if you wish to reach him. Considering those personal circumstances, I believe it is unlikely that my client will flee. He's too important to look after his family. And just to be clear, he has no Albanian passport. It is unlikely that he will go to Albania and become or end up out of reach of this court. As you know, in international human rights law, the rule is that an accused can wait, shall not be detained awaiting trial. He has the right to remain free unless there are special circumstances that require his detention. Special circumstances that require, that are necessary to assure that the accused will attend trial. I was a bit surprised. This is my first appearance in this court. I was a bit surprised. I received lots of documents, legal briefs, sometimes a little bit repetitive, which I studied at length, but I didn't find any evidence to support the allegations, the charges in the indictment. I suppose there must be supporting evidence, but I haven't seen them. My client hasn't seen them either, and I am stressing this point because it will be impossible for my client, because he doesn't know what the evidence is. He doesn't know whether there are any witnesses that have testified in this case. It will be very difficult for my client to obstruct justice in this particular case. His house was searched, I understand. His telephone was seized. I don't know what my client could do. I haven't got the imagination to imagine what he could do to obstruct justice in this particular moment. I was also told this morning, to my surprise, that not all accused in this particular case, and I'm talking about the bigger case, which will keep you busy today and also tomorrow, I was surprised to hear that not all accused were actually arrested, but some of them, at least one of them, was simply summoned to come to court, and he did show up. And I don't know, I'm quite keen to know, why in the other case summons was deemed sufficient and my client had to be arrested. I don't want to be rude, I don't want to upset my client, but he is a small fish in this investigation. There is contempt of court, which he allegedly assisted, and there is an attempt to influence a witness. If I understand the charges correctly, he did not succeed according to the arrest warrant and the confirmed indictment. He did not succeed in actually influencing a witness. The small fish, and I think that should be taken into account when taking a decision about the detention. So I would like to request the release on bail to Kosovo of my client, and I would like you to set the bill, Your Honour, at 2,550 euros, which is 3 times his monthly salary. And I would like you, or I would invite you to, Your Honour, to order any other measure or condition you may deem necessary to secure my client's attendance at trial. I don't think house arrest is a feasible option because he would need to go to work every day. But apart from that particular condition, I think I would invite everyone involved, Your Honour as well, to be as creative as possible. I also understand and heard you explain to my client that he is detained because there is fear that he might re-offend. I think it is easy to come up with a solution to that problem if he is ordered or if the condition is set that he's not allowed to leave Kosovo. I find it very hard to imagine that he will be able to re-offend as he is alleged to have done in this case before. Thank you very much.
Thank you, Counsel. Specialist prosecutors, you have the floor.
Thank you, Your Honor. Your Honor, I'll reply briefly to a few of the points that counsel has made. And in the main, I'll rely on Your Honor's findings, which are detailed in particular at paragraphs 81 through 92 of F00037, which I believe counsel has been notified and I presume has read. I'm not sure if that's one of the filings he's referring to as repetitive, but I want to talk about some of the findings in there. First, as Your Honor notes, and I think we're all clear on, the applicable law here in this room today is Article 41.6. And the standard for detention is whether it's necessary when the conditions under that are met. So let's talk about those conditions and factors. 41.6a clearly met. I don't think there's a dispute about that. There's a finding of a well-grounded suspicion for the 2 counts that have been read out here today and confirmed against Mr. Fazliu. So that one's met. The next 3 are the 41.6b factors, which are in the statute put forth in the alternative, meaning any one of them, if met, could be sufficient to necessitate the accused's detention. And I would submit that Your Honor's findings are entirely correct, that all 3 of them are met here, and all 3 of them necessitate his detention. So, on the score of risk of flight, we submit that Mr. Fazliu is a significant risk of flight, notwithstanding his family connections in Kosovo now. And as Your Honor noted, that may partially address and mitigate the risk of flight, but does not diminish or remove it. Mr. Fazliu is charged with serious offenses, the top one of which is an attempt to obstruct the proceedings of this tribunal in an ongoing trial for war crimes. He faces significant prison time if convicted after trial. that is a significant incentive to flee. Respectfully, the fact that Mr. Fazliu does not have an Albanian passport does not make it impossible for him to go to Albania, which is one of the many countries from which it would be very difficult, if not impossible, to extradite Mr. Fazliu back if he chose to abscond. And to your honors, and to a main point on the risk of flight, sitting here today, Mr. Fazliu has already demonstrated a blatant disregard for the rules of this court. He didn't not know what he was doing when he attempted to obstruct the proceedings and directly approached a central witness in the ongoing case here. He knew exactly what he was doing, and we know that, and counsel referenced his lack of ability to know the evidence. I will elucidate that point for a moment. Some of the evidence against Mr. Fazliu, and this relates to all three of the factors, but I'm addressing the risk of flight in this moment. Some of the evidence is in the form of audio recordings of him taking direct instructions to interfere with a witness and agreeing to do so, and then going and volunteering his son as a co-perpetrator to deliver the message, which by itself demonstrates a knowledge and understanding of how to try to evade justice. So that's where we're starting from. So I disagree that he is not a risk of flight, and again, emphasize that Your Honor's findings on that point have not changed at all today with anything that's been presented. On the other two factors, I'll collapse them into one. That's the risk of committing obstructions further obstruction in criminal offenses related to these proceedings, and his propensity or his likelihood of risk of committing other further offenses. And I submit that Your Honor's findings on these are instructive and accurate. His conduct has demonstrated, again, a blatant disregard for the rules of this court, and there's every reason to believe that Mr. Fazliu poses a risk of obstructing this proceeding, just like he did one that he wasn't even an accused in. Lastly, on the small fish point that counsel raised, I respectfully, again, disagree. What I would submit to Your Honor, and this is consistent with your findings, is that there are no small fish in attempts to tell witnesses, including ones identified as decisive by Mr. Thaçi, there are no small fish in attempts to interfere with those witnesses and tell them what to say when they come to court. The fundamental principle of this institution and any tribunal is for the ability of witnesses to come to court and testify truthfully and let justice play out and everyone have a fair trial. What Mr. Fazliu is accused of, and bringing his son into doing it, strikes at the very heart of one's ability to have a fair and just proceeding, and strikes at the heart of the integrity of this institution, and actually goes to the reason why we're all here having these proceedings here, because there exists, as found repeatedly, a climate of intimidation in Kosovo and witness interference in Kosovo. So I submit that Mr. Fazliu's role in this is actually quite significant. And then lastly, I just want to address the point that's been raised, and not for the first time, about musings or wondering about why another accused in this case has been summoned as opposed to Mr. Fazliu being detained. And my answer to that is simply, there is nothing in the statute that makes this a relativistic determination. Your Honor's job, as you know, is to assess Mr. Fazliu's facts as they apply to him, and the Rule 41-6 factors as they apply to him. Thank you.
Thank you, Mr. Prosecutor. Does the defense wish to respond?
Yes, please. I noticed that my last, regarding the last point, I noticed that my question as to why one accused was simply summoned and the other one was arrested has not been answered by the prosecutor. I'm still curious to know why a difference is made in approach. The other thing I would like to respond to is that apparently, something that we didn't know, there is a recording of a conversation, and I assume that is a conversation which happened in the detention unit on the 2nd of July 2023. If, Your Honour, if you decide to reject my request for immediate release, conditional release of my client, I would kindly request to order disclosure, full disclosure, not only of this particular recording, but also all the other relevance which is necessary to challenge the evidence and to make a proper motion to release my client conditionally. And if possible, to do it before the 17th of December, so that I can again ask for my client's release on the basis of the evidence which is lacking now.
Your microphone, yeah, thank you. Does the specialist prosecutor want to respond to this last point on disclosure?
No, Your Honor. Thank you.
Thank you. I will issue an oral decision after a short break before we conclude today's hearing on the detention of Mr. Fazliu. And at this point, I would like to ask the parties if there is any other issues strictly related to today's hearing that they would like to raise.
No, thank you, Your Honor.
All right, we will thus break for 40 minutes and we'll reconvene at 2:30 in the courtroom.
All rise. All rise.
Please be seated. We are back in session, and I note for the record that all the parties and the registry representatives are back in the courtroom. And I will now issue my oral ruling on detention. Defense Counsel, I have taken note of your request to release Mr. Fazliu on conditions. I've taken note of your submissions that there is no evidence on the allegations raised against Mr. Fazliu. I also observe your observations regarding the absence of a risk of flight, as you submit that Mr. Fazliu's residence is known, he provides for his family, and does not possess the means to flee to Albania. You also submit there is no risk of obstructing the proceedings, as there is no foundation that he would do so, and he doesn't know the evidence in the case. Moreover, I note that you claim there is no risk of commission of further crimes, as he may be ordered not to leave Kosovo. I've also taken note of your submissions that Mr. Fazliu is, I quote, a small fish, and have paid heed to his family, health, professional and financial situation. I've taken note of the specialist prosecutor's position that all requirements of Article 41(6) are met, and that therefore Mr. Fazliu should remain in detention. I note the SPO's position that Mr. Fazliu remains a flight risk, despite the fact that he does not own an Albanian passport. His past behavior, including by involving his son, shows that Mr. Fazliu has knowledge and understanding of how to evade justice. Further, it is the SPO's position that Mr. Fazliu is charged with serious offences, attracting a significant punishment, and that he demonstrated a blatant disregard for the rules of the specialist chambers. The SPO further rejects the notion of small fish, given the nature of the offences he is charged with. Having considered all arguments, I found that none of your arguments, defense counsel, are capable of changing my assessment in the conditions provided in Article 41.6 of the law that those conditions are met, as set out in the decision on arrest warrants and related matters, filing F37, paragraphs 43 and 81 to 92. Specifically, in the absence of concrete arguments, I'm not persuaded that there is no evidence supporting the finding of grounded suspicion as envisaged in Article 41.6a of the law. It suffices to note that the accused has received the submissions related to the SPO's request for an arrest warrant, and pursuant to Rule 102.1a of the rules, he will also receive the supporting material to the indictment within 30 days of today. Further, I'm not persuaded that Mr. Fazliu is not a flight risk. The charges against him, the gravity of the offences, and the potential sentence provide him with a motive to evade justice. I also consider that Mr. Fazliu would have the means and opportunity to flee by travelling to jurisdictions without extradition agreement with Kosovo, including Albania, even if he does not possess an Albanian passport. The fact that Mr. Fazliu has rooted family ties in Kosovo only partially mitigates and does not diminish the risk that he may flee, particularly seeing the role of his son in the facts and the charges alleged against Mr. Fazliu. The fact that he has special medical care in Kosovo has no bearing on the flight risk, as he can also be treated elsewhere. As regards the risk of obstructing the progress of criminal proceedings and repeating offences, I find that none of the arguments presented by the defense put into question the findings made in paragraphs 86 to 91 of the decision on arrest warrant and related matters. Therefore, having considered the parties' submissions, I determine that Mr. Fazliu shall remain in detention. The reasons for your detention, Mr. Fazliu, are the same as set out in said decision, paragraphs 43 and 81 to 92, which shall be read together with the present ruling. Accordingly, based on the information and material underpinning decision F37, and in the absence of any contrary intervening information or development, I find that, first, there is well-grounded suspicion that you are criminally responsible for the offences of which you were informed today, and second, there are articulable grounds to believe that you are a flight risk, you will obstruct the progress of the criminal proceedings, and you will repeat the criminal offences. Furthermore, neither the conditions you propose, Defence Counsel, nor any conditions I may impose on Mr. Fazliu are capable or adequate to mitigate these risks. Mr. Fazliu, I will review the reasons of your detention within 2 months or at an earlier time upon request or change in circumstances as provided in Article 41.10 of the law and Rule 57.2 of the rules. Defence Counsel, should you wish to file submissions on the next review of detention, please do so by no later than Wednesday, 15th of January 2025. Responses and replies will follow the timeline set out in Rule 76 of the rules. Should the defence decide not to file any submissions by the aforementioned time limit, I order the SPO to file submissions on the next review of Mr. Fazliu's detention by no later than Tuesday, 21st of January 2025. The defence shall respond, if it so wishes, by no later than Tuesday, 28th of January 2025. I will not entertain a reply. Lastly, Mr. Fazliu, you have the right to appeal today's ruling on your detention directly before the Court of Appeals within 10 days as provided in Article 45.2 of the law and Rules 58 and 170 of the rules. This concludes my oral ruling. This also concludes today's appearance hearing, and I wish to thank the parties and the registry for their attendance. I also wish to thank their interpreters, stenographs, audiovisual technicians, and security personnel for their assistance. The hearing is now adjourned.
All rise.